Good morning, everybody. Happy Friday. Welcome to the Courtroom Files Live. Let's start our day with Judge Middleton, who I believe is doing misdemeanor arraignments this morning.
Be set for a final pre-trial.
Well, let's do Kayla Coffee and then we'll do Mr. O'Shea. Would you bring Mr. O'Shea?
Pre-trial.
Well, let's do Kayla Coffee and then we'll do Mr. O'Shea. Would you bring Mr. O'Shea in?
Yep, I guess so.
Good morning. Are you Kayla Brianne Coffee? You have to speak your answer.
Oh, sorry.
Is that your name?
He's asking if that's your name.
Oh, yes.
All right. I'm sorry to ask such hard questions, but we'll see if we can get through this. You got charged in a complaint. Oh, that's wrong, girl.
Thank you.
Darn it, did the same thing. Here we go. The complaint alleges that on or about May 4th, that you assaulted Vance Long, someone you had a relationship with. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Also would prohibit you from using a firearm. According to your lawyer, Rhonda Ives, at this point, they wish to set this matter for final pretrial. Is that correct, Ms. Ives?
That's correct, Your Honor.
I can't tell that you owe us any money. It seems to me I met you in a landlord-tenant case or something. Did you have an issue with your landlord up on on downtown?
There was like a thing with my mom's ex-boyfriend where he owed him a bunch of money and stuff.
All right, maybe that wasn't your case. At any rate, it does appear that you're in compliance with the terms of your bond. You're not to have contact with this person, Vance Long. Where are you? Let me just ask, are you still at the South Main Street address?
Yes, I am.
And where is Mr. Long?
I think he's living with his father.
Okay. All right. You don't owe me any money. You appear to be in compliance with your bond. We'll set this for a final pretrial. What the prosecutor has offered to resolve the case is a plea to domestic violence with a deferral. There's a specific statute that allows the judge, with the prosecutor's consent, to adjourn, to remove the conviction from your record as a matter of public record if you successfully completed probation. That would include an anger management or domestic violence course, and we have a specific class for women. That would not prohibit you from using or possessing a firearm, and it would make the charge non-public if you completed the probation. So you can discuss that with your attorney, and I'll see you, we'll sit down with Ms. Ives, schedule all these for the same day. Do you have any questions?
I know.
All right, you're good to go. I'm thinking about doing my hair in that color. Good afternoon, Mr. O'Shea.
Good afternoon, Your Honor.
$27 days credit. Darn it. This is file number 25819 SM, People versus Jesse Joseph O'Shea. Mr. O'Shea is charged with domestic violence, second offense, alleged to have occurred on March 3rd in the village of Colon. The person assaulted was someone he had a dating relationship with, Marissa Smith. This is charged as a second or subsequent offense, making it punishable by up to a year in jail. They charged 2 counts of that. Prosecutors agreed to dismiss all of those for a plea to 1 charge of domestic violence first offense. Domestic violence first offense is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. It carries no points, but it does carry a firearm restriction to use or possess a firearm, but you already have that. Are you going to plead to domestic violence first offense?
Yes, sir.
Anybody threaten you to get you to do that
No, sir.
or promise you anything?
No, sir.
You weren't here when I went through the advice of rights, and it doesn't appear that you have one there. So let me tell you, by pleading to this charge, you're giving up your right to have a trial in front of a judge or jury. There will not be a trial. Do you understand that?
Yes, sir, I do.
If there was a trial, you'd have the right to be represented by an attorney. Ms. Ives is here with you. You could also hire an attorney of your own choice if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. You don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent, unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir, I do.
Let's take a look at this. Were you living in Colon at that time?
Yes, Your Honor, I was.
And you were dating a girl named Martha Smith, Marissa Smith?
Yes, sir.
And it says here that you got mad at her live-in girlfriend and grabbed her by the hair and choked her. She was actually taken to the hospital. Who called the police? So did you get into an argument with her?
Yes, sir, I did.
Did you pull her hair or choke her?
I did pull her hair and grab her by the neck. Yes, sir.
All right. Rhonda, you're here next Wednesday. I'm gonna set this. It's a little early, but I'd like to allow the prosecutor. I'm gonna set it for sentence June 4th at 11. Please provide notice to the prosecutor.
Is it possible we could do 11:30?
Yeah, your hearing's at 10:30?
It's actually at 11, but that guy's got like 12 cases.
Well, could we do it could we do it first? We'll do it at 10:30?
10:30, that's great.
All right. All right, you have a hold on you from Van Buren County. You've been in our jail for 27 days. So Ms. Ives is gonna be here on June 16th, but I don't wanna go that far out. So we'll set it for next Wednesday, June 4th at 10:30. Your bond is canceled. I want you to post bond and go to Pawpaw. We'll see if we can take care of this next Wednesday.
Fantastic.
You're good to go.
Thank you very much.
Ms. Ives. All right, I have a walk-in arraignment, if I understand this morning. That would be Mr. Mustafa Stewart. Would you come up to the podium? I don't think they even put this in my queue. Let's see if they did.
Well, Judge Middleton goes through one of his world-famous silent phases. Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Friday. It's a slow start out there, but all of a sudden a whole bunch of courts are starting to open up, so I'm scanning through them to see what's the haps and see where we want to go this morning. But we'll continue with Judge Middleton for the moment.
All right, Mr. Stewart, this is a ticket from the Village of Constantine. You got a charge of driving without a valid operator's license, which isn't all that serious of a crime. It's punishable by up to 90 days in jail. Let's see that this is charged. No license ever applied. They give you a warning for no seat belt and no tail light. Driving without a valid license ever acquired is a misdemeanor. It's punishable by up to 90 days in jail and fine of up to $100. You failed to show up for your arraignment. I indicated there may be a problem with your notice and try an order to show cause on May 15th. I'm not sure what happened, but you're here now. Problem is Mr. Bush is not here now. Are you still at the Water Street address?
Correct, Your Honor.
All right, you're from North Carolina?
I am, Your Honor.
All right, so the charge, let me tell you what it is. It's a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. Normal fine and cost is $200 or $225. If you plead guilty to the charge, I'm gonna give you a fine and I'll give you time to pay it. If you wish to plead not guilty for this, I have to set up for a pretrial with Mr. Bush here, and that would be on a Thursday morning. What would you like to do here today?
I would like to accept it, Your Honor.
Accept the plea offer?
I would.
All right, anybody threaten you to get you to plead to that
No, Your Honor.
or promise you anything?
No promises, Your Honor.
And you've been waiting a while. You heard me go through the advice of rights probably a couple times.
Correct.
Anybody threaten you to get you to plead to this?
No,
Promise you anything?
negative.
All right, I'll give you the same a piece of advice I give to lots of people. If you're driving around with a suspended license, wear your seatbelt. It gives the officers a reason to pull you over. All right, so did you get pulled over at about midnight on April 18th in Constantine?
Correct.
Was your license not valid at that time because you got issues in North Carolina?
Correct. That's right, Your Honor.
All right. Well, I'm gonna fine you $100, $75 crime victims' rights fee, and a $50 state minimum fee, $225. You have a driver here with you today, I see. You didn't drive here today.
Correct, Your Honor. I did not.
All right. Can you pay that by June 30th?
To pay today, Your Honor.
All right. Very good. So there's no warrant, no nothing. You just pled the ticket.
Excuse me, Your Honor.
Yes, sir.
I believe the deputy that brought me in, she
Yeah.
said I did
Did what?
have a warrant or something.
Well, I've just recalled it.
Thank you. I don't know how that works.
So, okay. All right, you can go pay your $225 fine. Don't drive anymore till you get your situation straightened out. But we got the matter taken care of.
Thank you, Your Honor.
All right, you're good to go.
Let's jump across Lake Michigan, go to Wisconsin, and say good morning to Judge Mogan.
Really old, it's not a really old case, but it's an old case, a 2020 case, a disorderly, domestic disorderly case. He's not from here. He was just here for a brief moment, no connections to here. He actually lives in Michigan. He hopped on a bus from Michigan, hauled himself here himself because he found out he had a warrant, turned himself in, and he had been in custody for 15 days. And then I had his initial appearance Wednesday. He had a public defender make a special appearance for him. We did his initial appearance, and an offer was presented for a time served with court costs. He was on a $500 cash bond with, whatever conditions. And then the court, I would have taken his plea that day, but the public defender was not able to go up and go over all the stuff with him. And so I set it for today with the potential of a potential plea, but lo and behold, apparently Mr. Feliski, the public defender, did not take the case, and you were appointed the case. Mr. Lothrop, I don't know how he did it, but he bailed himself out. And so he is now out of custody. But again, he's from Michigan, no connections here, literally rode a bus from Michigan here. And apparently he found some place to stay. I'm going to guess maybe at the motel. I don't know. And so I have him in our Zoom room right now. And so I want to send you to a Zoom room with him to talk about the case. But again, it's a simple disorderly conduct, domestic abuse. The offer was plead to the charge, time served, costs.
Yes, Judge. Again, I tried to reach him on the number we had. It didn't work. So if I could have the breakout room, that would be excellent. I'd be very appreciative.
Yeah, the number, because he was in custody, and then honestly, I don't think I verified his telephone number because I didn't believe he was going to get out of custody. That's why it was such a quick little turnaround, and because of the less serious nature, domestic abuse, but it's 2020 case. That's why I didn't verify his number. So Mr. Lothrop and the Zoom room, can you hear me? I can't hear or see you. Yeah, it's just taking them a little bit of time. Sometimes it does that. So as soon as he's up and running, then I'll set you with Mr. Lothrop, then we'll get on to Mr. Belial.
Yes, Your Honor.
Or I guess we can do this. Well, there they go. Yep, I can hear. There we go. All right, Mr. Lothrop, I'm going to put you in a confidential breakout session with your attorney. This is Nicholas Davis. He is your counsel, and he's going to be talking to you about the matter, okay? Mr. Davis, have you had an opportunity to review the criminal complaint?
Yes, I have, Your Honor.
Okay, thank you. I've opened the room.
Thank you very much, Your Honor.
All right, Mr. Belial, I'm going to put the court into the waiting room while they're having their breakout session, and then we'll come back, okay?
Okay, well, we're waiting for that to happen. Let's head down to Texas and see Judge Boyd.
Diaz, could I have parties announced?
Attorney for the state of Texas.
Martin Guetta, attorney for Brandon Diaz.
And are you Mr. Diaz?
Yes, Your Honor.
All right, this defense has requested a bond. He's entitled to a bond because it's a deferred adjudication. My understanding is that you all have made an agreement for $10,000. Is that correct?
Sure.
Does anyone have the allegations in the motion to revoke
Your Honor.
so that I can set appropriate bond conditions? Oh, okay. All right, thank you.
Yeah.
All right, and what is the alleged? Ah. Oh, thank you. All right, so I'll set your bond at $10,000. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Brandon Edward Diaz.
All right, so have you used any type of drugs in the past? No marijuana, no alcohol, nothing?
No,
All right, have you ever been diagnosed with any mental health issues?
that I'm aware of. I know that I have anxiety, but never been diagnosed with it.
All right. All right, what I'll do is I'll follow your agreement, set the bond at $10,000. I'll do the referral to Center for Healthcare Services. If you go there and they discover that this is normal anxiety, it's just maybe anxiety about your legal matters, then they may decide something different for you. But just to be on the safe side, I'll do a referral for that.
Okay, thank you so much, Your Honor.
You're welcome. All right, so we can go off the record. So is this going to be a contested?
I need to speak to the prosecutors over in the county court first, Your Honor. I'm just getting discovery on that new case.
Additionally, Your Honor, I guess while we're off the record, Stewart just asked as part of his bond conditions, the victim that was involved in the original injury to a child charge, if there was and no conflict order, that still be in place.
Oh, let me see.
And actually, that's
Moment, Your Honor.
Sure.
I don't think there's a need for that. He does have regular contact with his children, his child.
Well, what
And
I
there's
can,
not a no contact order as a condition of probation.
all right, well, what I can say is during, and I think I'm very thorough when I'm setting conditions. And if there would have been an issue at the time for him having contact, I would have had it in the conditions of probation. And those conditions are not in his conditions of probation. I'll have probation double check just to be sure though. Bashan, on this case, do you know if he has a no contact order in place with the complainant? I don't think there is, because if I remember this case correctly, the injury wasn't, it was an injury, but it wasn't
No, Judge, there's no.
done intentionally.
Right.
No, Judge, there's not a no contact order in place.
Okay,
And he has completed his parenting class, Your Honor.
yes. So it was, the injury had to do with
there's a discovery not
evading. Yeah. I will tell you this, but what I am gonna add to his conditions of bond is I'm adding no driving. Because obviously, and I'm not taking what they're saying is true, but you shouldn't drive.
Yes, sir.
All right. Then, Ms. Ferguson,
Yes, ma'am.
can you put this for a contested hearing the week of June 23rd? Then counsel, if it turns out it's not contested, that's fine.
Okay.
All right, so it'll be June 24th. And if it's not going to be contested, counsel, if you'll let probation know before that date.
Yes, sir.
All right, Ms. Ferguson, he needs a reset form for June 24th. All right, thank you.
Thank you. Thank you.
All right, Judge Mogan is back in court, so let's head back there.
I guess I can, if you want, I can, I'll wait. Do you want me to wait for him?
You can update me. He's in here right now.
Your Honor, I did go through the complaint and I've reviewed it thoroughly. And I did speak with him and I explained to him what his options are and what was going on and what would happen. And he wants to do the plea today. And I did go through the plea colloquy with him, Your Honor. And obviously you would do it again, but he wants to plea right now to count 1, which is disorderly with domestic. I explained to him the repercussions of that. I know that state's looking for just court costs and fine, but he wants to plea today, Your Honor. He's prepared to go forward. And I went through him thoroughly and explained to him that I'm not rushing him. No one's forcing him. And he wants to do it on his own volition. And he's very adamant about it, Judge.
All right, that sounds good. All right, I'll take up your case in 1 second, okay? I have to quick have Mr. Belial's status. We will go on the record in the matter 24 CF 245 24 CT 102, State of Wisconsin versus Jason Belial. The state appears through District Attorney Kevin Schmidt in person. Mr. Belial appears by video conferencing in custody in Burnett County Jail. We have his counsel, Nicholas Davis, also by video. We're set today in this matter for a status conference. Mr. Davis, can you please update the court?
Yes, thank you very much, Your Honor. Your Honor, I did speak with Jason. Right now, he's on a hold, probation hold, and he's going to be released, I think, in a couple weeks. I know there is a cash bond, but at this time, the case is not resolved. All I can tell you is that when he's released or when he puts up his bond money, Judge, I know that he's going to be trying to enter a treatment program. I know that he has, now I forget his name, Jack, the individual up in Superior. I know has contact with him, and he's also has a program here locally through the tribal center. And so that's what's going on. But as far as the case being resolved, it's not resolved. But hopefully if you get into treatment, I think that would be a good start.
All right. Mr. Belial, other than the Pastor Jack part, was Mr. Davis referring to the healing center?
Yes.
Yes, Your Honor.
Okay, thank you. Okay, so we need perhaps a status to have all of that flush its way out, and perhaps there could be a potential agreement. Has an offer been extended?
Yes.
What was the offer?
It was, I gave three possibilities, either pleading the meth for 2 years probation, or if he gets AODA before pleading, plead to amphetamine for 1 year probation, or if he does AODA and gets his license before pleading, just amphetamine for costs.
Okay.
And Judge, our goal is to try and do a non-felony disposition. That's what we're trying to work forward to. And I forget, Jason, when is your probation hold finished?
When?
The 14th.
Okay.
And it shouldn't take long for him to get into treatment, Judge, or get the assessment, because he's already had contact with these individuals.
No, it shouldn't. What about July 10th? Are you available in the morning?
I'm unfortunately I'm not.
I thought you had a trial. What about July 7th at 10:15? I either have 10:15, 1:45, or 2:45 on that day.
Sure, Hunter, I'm going to do something crazy, but may I have the 2:45 and may I appear by Zoom, because it looks like I'm in a trial in Hudson, but I think I can break free if I have to.
Yes, that is fine. July 7th at 2:45.
And Jason, that means you must be enrolled in a treatment program by then.
Yes, yeah, yes.
Okay.
No, I'm not the
All right. Anything else, Mr. Davis?
No, Your Honor. Thank you very much.
Thank you. Then we are adjourned as to Mr. Belial. Mr. Davis, I am not sure what is going on with Mr. Benjamin, because there was a request from Ms. Landgraf to adjourn hers 30 days out because of the revocation decision.
I am ready. I can tell you, actually, I think I can give you a very good update.
Okay, are we having a plea and sentencing? Are we just pushing this out, or what's going on?
We are, I think we are, but so Your Honor, I'm not trying to get you involved in the negotiations, but there's a global on this. And the cases I represent him on, he'd be pleading to disorderly conduct in 24 CF 150, and then obstruction in 24 CF 250. Those are my cases. However, Judge, on the disorderly conduct, the state wanted 90 days jail, credit for time served of 120 days. The only thing that we're nervous about, Judge, is that time, we don't know if it counts because it was time used for his probation, his revocation on probation. So if we can somehow take that out of the equation, because he has sat that time and we just not included, I think we do have a global on everything. That makes sense. He doesn't want to get stuck with that,
Right.
that,
I think that would be a call of the district attorney as well, if he would stipulate to that though.
and I would ask Kevin if you.
I mean,
would
if they're
consider
concurrent,
that.
what does it matter?
That would be the issue. I mean, I think exactly what Mr. Schmidt said, if it runs concurrent, it wouldn't really matter because it was, these cases arose while he was under probation of the other matters and he was taken into custody. So it shouldn't affect it. And the district attorney, by what I'm hearing, would stipulate that they would apply.
Judge, and I think we can set this for a plea. I think we can get a plea date.
And not worry about Ms. Landgraf's case or wait
Well-
until they're all one deal.
I shouldn't say not worry about her case, but I did include what the district attorney wanted out of her case, and he's fine with that. So obviously he has to speak to her, but if we could get that, you want to know what, Judge? That July 7th date, after that, you said you've got some other times on that July 7th date. I guess I would try and squeeze this in for a plea too.
Well, let me just quick look. I want to look to see when Ms. Landgraf's was rescheduled.
Oh.
Hers was rescheduled for a plea and sentencing on June 25th at 3:30. Does that work for you, Mr. Davis?
It does not, Judge, but is there any?
Even Zoom?
I'll make it work. I'll just make it work. If I can do it by Zoom, I've got a court trial starting at 4 o'clock, but bench trial.
We'll be done by then.
Okay,
And you can appear by Zoom, no problem.
thank you very
Where's your
much.
court trial?
Turtle Lake Municipal.
Oh, yeah. Well, you can appear by Zoom from there and then we'll be done before then.
I'd appreciate that. Thank you.
All right, June 25th at 3:30, June 25th at 3:30. And Sudie, so you're aware, I don't know if you're aware, we do not need Aaron Benjamin.
Oh, can you do it through Zoom
We don't need him at all today.
at all? Oh.
Nope, we're
okay.
good.
Okay,
So-
I'll let him know. 'Cause that's what I was
Okay,
just
thank
bringing
you.
up. Thank you.
All right, let's head back over to Michigan. We'll say good morning to Judge Meineke, see what he's got going on today.
Bear with me 1 second, Mr. Phillips.
Sure.
So while Judge Meineke gives us the silent treatment, welcome again, everybody. Happy Friday. Good to have you all here. If I don't say it enough, let me say it again. I appreciate each and every one of you. Y'all pay me with your time and your loyalty, and it's very much appreciated. So thanks so much. If you're new here, welcome. Consider subscribing to the channel if you're not already. We've got a nice little community here that interacts really well, and we have a lot of fun. All right, looks like somebody's talking now. Let's get back to him.
This on the jury trial docket.
Okay. We can do July 28th,
Hey, good morning.
July 28th, or August 25th, or September 29th.
I mean, the July date works for me, Your Honor.
Ms. Rosendahl, is that fine for you?
Yeah, would you mind repeating the July date one more time, Judge?
28th.
That would be fine.
So the court is in receipt of some alleged bond violation issues or concerns between Mr. Sweet and Ms. Redmer. Frankly, we just need to reinforce, it looks like, the conditions. Mr. Sweet, it's my understanding that, or at least some allegations, that there's contact that's occurring through an app called WhatsApp rather than using the court-ordered communication app. I don't want you to make any comments about that right now, but I just want to reinforce that the court has ordered that the only way that there could be any type of communication between you and the complaining witness in this case is through the family wizard, and anything that occurs outside of that from this moment going forward will be considered a violation of this court's no contact order and subject to immediate bond review, which could include up to revoking of the bond. Additionally, one of the court orders was to make sure that all family court orders are followed. It does appear that there was some issue that came up on May 15th regarding parenting time. I just would reinforce that you are to follow this court's orders and the family court's orders, and that could be perceived as an attempt to violate the no contact order or to harass, intimidate, or otherwise threaten the victim. And so I would just encourage you to follow to a T all orders, not just mine, but the family court orders as well. And if you have any questions regarding that, make sure to run it by Mr. Phillips or your family court attorney before you engage in anything that could run afoul of the court. Finally, it looks like it looks as if there is a request, because it wasn't made clear on the bond order. The police report has a Glenview address listed. I'm not going to get the specific address, but I think both the prosecutor and defense attorney can simply look at the police report and make sure Mr. Sweet knows that my no contact order extends to that to the Glenview address that is listed in the police report, which the victim has asked for clarification to make sure that Mr. Sweet knows that he is not to return or have any contact with that property. As a final reminder, Mr. Sweet, while on bond, you of course are not allowed to go to any bars, clubs, or liquor stores. So, Mr. Phillips, I don't want to get into a back and forth with your client because the court is not running a bond violation hearing right now. I'm just simply advising your client of the specifics of the bond order, and that now there can be no mistake or misunderstanding. From this point going forward, Mr. Sweet should be more than capable of following this to a T. And if not, then by all means, we will have a bond violation hearing, and there may be some results coming from that, Mr. Sweet, that you definitely do not want. So, Mr. Sweet, are we on the same page?
I don't believe so, because I asked for this specific clarification from the officer that is my supervising officer. I specifically asked if I was allowed to be in a restaurant that has a bar, and she said yes, absolutely. So I'm not sure of the specifics of what you're talking about, but I regularly take my 4-year-old daughter to the burger place that's at the end of the street. And there is a bar inside the burger place, but I specifically asked, am I allowed to continue to go to the burger place? And the supervising officer said yes. Also, the WhatsApp communication, my daughter calls me. So she calls me. And I asked if I'm allowed to talk to my daughter. It's just that she uses the victim's phone to do it. So the records are going to show that it's the victim calling me. So then I asked the officer, am I allowed to still talk to my daughter on WhatsApp? And she said yes.
Mr. Sweet, I don't know quite how to explain it any further. The if it's a hamburger place that just so happens to have a bar, then no, that doesn't qualify, and the court's not going to have an issue with that. But if it's a liquor store, or a facility that is just designed for the serving of alcohol, the primary purpose of it, I wouldn't say that a burger place, the primary purpose is for the serving of alcohol. So, Mr. Sweet, I think the supervising case manager gave you the right information on that. But you should be nowhere near the bar area, and you should be absolutely not consuming any alcohol or anything like that. But as far as the WhatsApp, you're gonna have to figure that out with your. I would talk to Mr. Phillips about this. I would talk to your family court attorney, because, you know, again, if there is any evidence, if the victim brings any evidence to me that you have any contact with her on that app, with her, not your daughter, with her, if that happens, then that's on you, and that's going to be a violation. So I would definitely make sure, if I was in your shoes, to clarify with your attorney and your family court attorney, you know, how do I manage this communication with my daughter, so as to not violate my no contact order? Because if, you know, if during this process, Mr. Sweet, you're contacting your daughter and then say, well, let me talk to your mother for a minute, or you send some sort of message or something along those lines, or, you know, outside of something that was previously scheduled in family court, you reach out on the WhatsApp app and say, can I talk to my daughter right now? That's a communication with her that's not authorized. And so, again, I'm just trying to provide you further clarification. Of course, you're not prohibited from having contact with your daughter, but necessarily when the person in charge of her care is someone you're not allowed to have contact with, you've got to really dot I's and cross T's and tread lightly, because any sort of communication that's with her that's outside of the family wizard is not something that's authorized by the court. So that's the best I could tell you, Mr. Sweet. And so I would definitely run that by your attorney to make sure, because at the very least, you don't want the victim to come in here, running here and say, look, see, he's actually having communication with me. I mean, if I were in your shoes, I would work very hard to protect myself from any sort of misunderstandings. And so I appreciate you reaching out to your case manager, but at this point in time, I think I've made it pretty clear. The burger place, if it's just a burger place that so happens to have a bar, the court's not going to violate you for that. And I'm not going to stop you from having contact with your daughter, but you've got to make sure that you are very cautious in how that happens, so as to not have any direct contact. I don't know if it's a circumstance where you then go through the family wizard and say, what is the best way to handle this? I would suggest that you talk to your family court attorney and bring it to the front of the court, and make sure that you are not putting yourself in a position where you are violating this court's order, because the family court is not one that can revoke your bond, but I can. Mr. Phillips, any other comments, questions?
No, Your Honor, we did talk about the restaurant issue, so we're well aware of that, and I'll have a conversation with him about the WhatsApp and Family Wizard.
We just gotta, this happens, Mr. Phillips, we handle many, many cases like this, all right? This is not the first time we've had to, come up with an effective plan, but, I just trust that in the meantime, while this case is pending for trial, that you'll work with Mr. Sweet so that he's protected. Because I mean, in the end,
yes,
that's the key. Because
that's correct, Your Honor.
If Mr. Sweet, I know that it's tough to hear these things, but at the same point in time, the court is giving you a heads up as opposed to jumping to any conclusions or bringing you in here for a bond violation. I'm just saying, hey, these are issues that I could see coming up in the horizon. Make sure you cover yourself and go about this all the right way.
Understood, Your Honor. And like I said, I don't think Mr. Sweet's doing anything intentionally. I think he's trying to tread a fine line between being able to exercise his parenting time and following the court's orders, but we'll have a further discussion about making sure to follow the bond to a T.
And Ms. Rosenau, I would just ask that you follow up with the victim and just make sure that she understands as well that some of the things that she's bringing to the court's attention are also issues that might be best handled in the family court. But But the court is certainly mindful and we'll try to work with the parties as best as possible to keep everybody safe and allow this process to go through unencumbered by any interference. All right, good luck, everyone. Thank you. Thank you, Mr. Phillips.
Of course.
And the children will suffer because the adults can't figure stuff out. Oh well. Let's go to Texas, Judge Boyd, see what's going on.
All this water piling up. Yes, and you have people who are driving their F-150s, just splashing water on other vehicles.
What's even better than you splash it on pedestrians?
Oh my gosh, yes. And so, and I don't know why this happens. You know, when water gets splashed on your windshield, what is your first reaction?
Oh my God.
Yes. Yeah, you go shots. And I'm like, open your eyes, Stephanie, before you crash. So yeah, that was my experience this morning. People just, but I'm glad I didn't wash my car yesterday. Although my mom always says, if you wash your car and it rains the next day, it won't be as dirty as it could have been. So either way, it's good. All right, we're going on the record. The court is calling 2019 CR 8716 State versus Andre Moody. Can I have parties announce?
Defendant for the state of Texas.
Albert Chidas for Mr. Moody.
And are you Andre Moody?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Andre Alonzo Moody who was placed on deferred adjudication in 2019 CR 8716 for the offense of assault, family choking, impeding breath or circulation on June 24th, 2020 for a period of 6 years and extended for 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, we're here this morning on state's motion to supplement pending motion to enter adjudication of guilt and revoke probation.
Oh, I need the supplemental. I don't have it.
I can.
Thank you. All right, Mr. Moody, did you review the state's motion to supplement pending motion to enter adjudication of guilt with your attorney, and did you understand it?
Yes, ma'am.
All right, state, you may proceed.
Yes, Your Honor. Violation condition number 29, on or about the 23rd day of February 2025 in Bear County, Texas. The defendant, Andre Alonzo Moody, did not comply with the rules and regulations of the GPS device 2019 CR 8716 in violation of condition number 29.
How do you plead to that, true or not true?
True.
State, do you waive the other allegation?
There's no other allegation there.
No, there is, because this is the supplemental, so there is an allegation.
Yes, fair. We waived the other allegation that was in the original work potential.
Any objection? Oh, no problem. Any objection?
No objection, Judge.
All right, Mr. Moody, did you understand by pleading true to violation of condition number 29, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 29? Court will find violation of condition number 29 true. Is there a proposed agreement?
There's not, Your Honor. I believe we're both going to go open to Your Honor on the appropriate punishment. Given that, just from the state's perspective, we're here on the defendant's third motion to revoke, Your Honor. His first one was filed, looks like it's 3 months after he was initially placed on probation and being placed in June 2020. He was first MTR'd in September 2020. And at that time, his conditions were amended to include a TAP evaluation. He was extended for 3 years. Then we come back about a year ago in June 2024 for his second MTR, where the conditions were altered and amended again at that point to add no contact with the victim and partial GPS. Additionally, Your Honor, over his history of his probation, he has had 5 positive tests for marijuana. He has had 2 trips to Bear County outpatient treatment. At no point had he attempted to even begin his parenting classes in almost 5 years of probation. He has not completed any of his community service hours. He has not paid any of his fines and fees. it appears to the state that he's not interested in completing his probation as required to by your honor, and therefore we feel that 3 years prison would be the appropriate sentence.
All right, in defense?
Judge, I'd like to call my client as a witness, just.
Sure. Would you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so that the court reporter can hear. If
Yes.
you state your name for the record.
Andre Alonzo Moody.
Mr. Moody, you've been on probation for going on how many years?
5.
Okay, and in that time, have you had a place to live?
No. Recently, through that time period, I lost all my family, my mom, my sister, my brother, my dad. And so I haven't had nowhere. I've been struggling. I had to, when my sister passed, my mom took care of the funeral and the cost. But after that, when my mom passed the following year, I had to do it. My brother's in California. He passed in California. My dad was in California. He was in prison in California. So I had to take care of that. So everything that I was kind of like my little stride that I had, my gainings, I lost it. I had to pay for my mom's funeral. Then I had to afterwards pay for my dad's funeral. Then I had to pay for my brother's funeral also. So it kind of took a toll on me financial wise. And for a while I was just depressed. That's what happened with the first violation. When I lost my sister and my mom, I kind of didn't want to be here, like a lot was happening. So
So let me ask you this, so, were you living at Haven for Hope, or were you on the street, or what was your situation?
first temporarily I was with Siobhan Sims, which is mother of my kids, which is the one I have this case with. And
Why were you with her? Didn't you have a no contact order?
no, that was prior to now.
It was after I think the second NTR.
Okay.
I was with her because we had kids together. My daughter was the main reason. My oldest daughter was the main reason I kind of just wanted to be here. She kind of always wanted to be with me, like through everything. Like my youngest daughter always wanted to go Siobhan, and my oldest daughter always wanted to be with me through them times. She wanted to stay with me.
Okay, so let me ask you, in this time that you've been on probation, have you had any kind of employment?
Off and on, because I was working at Hooters for a while. But again, the consecutive passings of each family member kind of took a toll on me, and I just drifted. Mentally I wasn't there for a while, and I started kind of reading the Bible. Start putting.
Does anybody have any Kleenex? Do you need that for your ear? Oh, okay, yeah, that would be better than your finger. All right.
Yeah, so
So you did work, at any point I know you've been moving around, did you lose your ID or social security card?
yes, twice actually. Oh, well, right now I'm on my 11th social security card. And I don't know if anybody knows this, but after you're only supposed to have 10 in a lifetime. Right now I'm on my 11th. I just recently got that back like 3 days before I came to jail. The caseworker at Haven for Hope, she gave me got my birth certificate for me. I haven't had that since I was 17. So I was kind of just getting stuff together, because when I first got out in October 2nd, it was hard because I didn't have nothing. Like again, I had to get my ID back. I had to get my social. And while it was being my 11th social security card, I can just order it on my social security like I would usually do. And everything is through appointment. So I had to make an appointment to get my ID, but you have to have one to get the other. And that was like I finally was able to get the paperwork from the jail, a printout of a photocopy. I don't know what it's called, but I was able to get that, and the ID place took it and gave me my license, which was December like 14th. I went to the appointment and I got my license around January. And then I had to schedule an appointment for Social Security, but they're not taking walk-ins no more. That's an appointment. So I had to wait till February like 18th to go in to get that. And I just received that 3 days before I came to jail. Now was the problem with my employment. I wasn't able to get a job because I was working at a temp agency, which I came to see you in February because it was kind of hard to get myself together because I couldn't get the job. And the only job that I was able to get, GPS didn't want me to do it because it was a temporary job. So I kind of fell off with that, because I was working there. They didn't want me to work over a certain amount of hours. I was trying to get them.
Okay, so let me interrupt you. So you've got your ID, you've got your driver's license, your birth certificate now, right?
Yes, my case manager at Haven has my birth certificate.
Okay,
And they were also willing to help me with an apartment. All I had to do is get a job, a real job, as they call it, not a temp service job, consistently, and bring them 4 checks up. They would have paid my first month's rent because it's a program that they have. And, I never got that opportunity because I was arrested as soon as I got all my,
okay. And so in this time that you've been on probation, some 5 years, have you been rearrested?
Yes.
You've been picked up new cases?
I haven't picked up no new cases. I've just been struggling to get on my feet. Every time I start to get like kind of the ball rolling, I always come to jail. And I lose everything again. I don't have nowhere to put it. You know what I mean? I leave it with certain people. It's not there when I come back. I have to consistently start over.
Okay.
And that's where I'm at right now. Right now, I'm at another process of starting over. And again, I finally got everything that I need to be able to work, to go do what I need to do. I'm interested in going to school. It's what I'm trying to go for welding. I was in school going for business management recently, but that was like 2020 after my mom passed. I kind of cut that off too.
Let me ask you, the violation is that you haven't been complying with the regulations, the rules pertaining to the GPS. Did you visit your kids?
I wasn't able to often, but my daughters, especially my oldest daughter, we have like a tight bond. So if I don't go like a long time without seeing her.
Okay, so his question was, were you visiting your children? That's the question.
Yes, ma'am.
Okay, and the kids are in the custody of Siobhan?
Yes, ma'am. Yes,
Okay.
sir.
And you know that after the second MTR, they said no contact with Siobhan Sims.
Yes, sir.
Did you talk to her about visitation?
Yes. She had called me while I was standing in Haven for Hope. She called me twice, and I didn't answer because of the no contact order. But she texted me and she told me my daughter wanted to speak with me, and I told her to have her call me, and they video called me, and she was crying. She said she wanted to see me. I haven't seen her in a month. So that's how we set up the arrangement for me to meet with them at the park, and I played with them at the park for about an hour and a half. And I left, and that's how I picked up the violation number 29.
Okay, and do you want to stay on probation?
Yes, I do need the help because I'm struggling by myself. Miserable. It's hard, and it's been times I don't know where to go. And I do have somebody that's kind of like willing to support me. It's a friend of mine. Possibly girlfriend, just to be honest. And
Well, to be honest, here's the thing. This is what the problem is. He's been on probation for 5 years. He hasn't done anything. The only thing you keep doing is you keep picking up more violations and you haven't learned anything. Now you're saying, I have somebody to support me. That's the problem. You're supposed to be supporting yourself. You're hanging your star to this person to support you. If something were to happen to them, or if they were to break up with you, we'd be right back here on another day with you telling me that you've lost your relatives, which I'm sorry to hear about that, but you were here before saying the same thing. And now you're back again saying the same thing. And now you have somebody else that you're going to be with hanging your star to her. And I think everybody deserves a chance. I know there is love out there in the world, but you got to ask yourself, what is going on in her life that she's decided to hang her star on a person who has no job, who has no home, who has a criminal case pending and is not taking care of his business. So that relationship, I can tell you, that relationship is not going to work out because at some point in time, she's going to get tired of having to lift and carry you on her back. She's going to want you to carry her once in a while, and you can't do it. You can't do it financially because you don't have a job. You can't provide her a home because you don't have one. And as you said it, you're probably going to need another Social Security card because the jail is probably going to lose it. So you haven't done anything. In 5 years, why have you not completed parenting classes in 5 years?
It's $25 a week.
All right. So in 5 years, why have you not had a job? How are you supporting yourself? Were you living off your mom, living off your dad,
No, ma'am.
living off of relatives?
I was working at Hooters prior to my mom. I actually had a savings account and everything. But
So why haven't you paid $25 for parenting classes?
that was prior to me even being on probation. My mom passed in 2020. And my sister passed before that. And the funeral, my mom don't even have a headstone for her.
No, I understand that.
It cost a lot of money, and I never knew how much it cost. I didn't know, I was just.
But here's the thing, you haven't done anything on probation, nothing. None of the requirements I've set for you, you have done. You have done nothing. Now, with regards to the marijuana, I know you're testing positive for that and you have a prescription. So that's the only thing you've been able to do. You got a prescription for marijuana, but you haven't done parenting classes. You've done nothing. And you haven't done your BIP class. You haven't done anything.
That's $25.
Here's the thing. You're using the fact that you don't have money for anything, not to do anything. And if you were to come into this courtroom and say, Judge, I haven't done the parenting classes or the BIP class because I don't have any money. If that were the allegations in the motion, I would be like, okay, you know what? He hasn't violated his probation at all. He just hasn't been able to do that because of funding. But that's not the case with you. You have done nothing.
Everything that I haven't done is because of funding is what I don't have.
No, you violated your probation 3 times. All you had to do was not violate your probation. You haven't done anything. And there's nothing that can be said today that will make me think that you're going to do anything when you're released, because every time you come before me once, another judge, another time, and every time you come before me, you have all these plans and you always have somebody. I found somebody who's going to help me out with this now. You're not taking any responsibility for anything. And how old are you?
I'm 32.
You're 32. You're going through life thinking that somebody else is supposed to be responsible for you, and they're not. Everybody gets hit with problems. I know funerals are expensive. That's why I decided I wanted to be cremated, and everybody else is saying, I want to be cremated. And you know what they started doing? Raising the price on cremation. I remember you could get cremated for $2,000. Now it's up to 10. So I understand. Who knows? Maybe I'm just going to die in my house and have somebody let cats come in my house and eat me. I don't know. But what I'm trying to express to you is it is not anybody else's duty to take in an adult male and support them. You're not even supporting your children financially.
Right.
That's another violation of probation. So in the 5 years that you have been on probation, you haven't even supported your children because you don't have a steady job. But here we are, we're going out procreating and we don't have our lives together. I just don't think probation is appropriate for you. And there's nothing else that I can do for you anymore. I've tried my best. I've told you to pick up the phone, call probation when you need something, come into the court if you need something, and you have done neither. The only thing you've done is violate your probation, and you violated it 3 times, and you've been extended, and extending you doesn't help. You should have been done with this probation, off with this probation, because you've been on this probation for 5 years and have done nothing.
Ms. Ford, can I speak one more time?
Sure.
I just got, like I said, I just got my social security card. I came to you in February.
Here's the thing, when you were placed on probation and you got your first motion to revoke, you had just got your social security card and you're telling me you're getting your life together. And 5 years you do nothing.
And yes, ma'am, and that was my fault because I kind of put, like you said, I kind of depend on other people too much in this, like right now. I depend on a lot of people instead of trying to get things done myself, but I do try to get stuff done, Ms. Boyd. There's been many times that I've been searching for jobs and it just told me no, and I did have an opportunity for a job right before at Denny's. I know it doesn't quite mean anything, but I got my income tax, on my car. I haven't even touched
Here's
it.
the thing, I don't even understand how people are getting an income tax refund and they don't have employment.
I was working last year partially for it.
All right, and you didn't pay $25 to do parenting. This is what the court is going to do. 29 is true. The court is going to grant the motion, revoke you. Find you guilty, revoke, give you credit for any time served. Does anybody want to speak with regards to time?
Judge, we would just ask for the minimum. All of these have been technical violations. He just can't get his life together. He's not out, holding up a Valero gas station, anything like that. So I think that based on that, the minimum would be appropriate.
And state, what are you requesting?
I'll defer to the court, Your Honor.
All right, the court will sentence you to 3 years in the prison, give you credit for any time served, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal, oh, and I'm sorry, there's an affirmative finding of family violence. You have a right to appeal, and that right to appeal is a limited right to appeal. It relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, can I ask one more question?
Sure.
So I do have 390 days or 300 and something days. Is that accounted for as 2 for 1?
Anytime that no.
No.
So here's the thing, this is a misunderstanding that people have. The court is not in charge of whether you get 2 for 1 or day for day. That has to do with whatever facility you are at and whether or not they decide to give you credit for that. What I can tell you is I sentence you to 3 years. You will do no more than 3 years. All right, good luck to you.
Thank you.
Thank you, Your Honor.
Well, so the final vote was 67 to 33 to yes, this gentleman will get his life turned around. But a lot of the vote came in before judge started picking him apart. So I'm going to put up a poll in a second and ask you if you would change your vote based on what you know now. So hang tight for that. Geez, Ellie. She literally just tried to hop over the microphone and came up short and made my arm bleed instead. So I'm going to switch this over to Judge Mom. Bandage up my arm, put up a poll, and the show will continue.
Counsel, have you received all discovery? Did you review it with?
Never mind. Let's just stick with Judge Boyd because she just brought somebody else up, and then we'll go to Judge DeSanto.
Did you review the true bill of indictment and each of these cause numbers with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We waived.
State, are you proceeding on the indictments as presented in the cause number ending in 6-8?
Cause number 6-8, Your Honor, we are proceeding on count 1 and waiving count 2.
Any objection?
No objection.
And the cause number ending in 6-7, are you proceeding on the indictment as presented?
Judge, and the cause of ending in 6-7, we are proceeding on count 2 and waiving count 1.
No objection.
And then Judge, just we're waiting the repeater enhancement on it, so.
Thank you. All right, Mr. Ortiz, did you review the documents entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And the cause number ending in 6-8, the state is proceeding on count 1, which is possession with intent to deliver. Penalty group 1, 4 to 200 grams. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. And the cause ending in 6-7, the state is proceeding on count 2, which is a possession of a controlled substance, penalty group 1B. Uh, 400 grams or more as a first-degree felony. The range of punishment for that offense is anywhere from 10 years to 99 years or life in prison and up to $100,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering these pleas, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ortiz, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No contest.
No. Has anyone threatened you or
No.
placed you in fear or coerced you to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page in each of the cause numbers?
Honor.
And the cause number ending in 6-8, the state is proceeding on count 1. And in the cause number ending in 6-7, the state is proceeding on count 2. They're asking that your punishment be assessed at 14 years in the prison. There's a $5,000 fine. There's no applications. The causes will run concurrently, and the state will take in consideration 2025 CR 000621. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Then, and the cause number ending in 6-8 to count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
And the cause ending in 6-7 to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
State offers states 1 and attachments in each cause.
No objection.
Any state you may be excused? I'm sorry, the dismissal.
I have to fill it.
Okay, thank you. And each cause number, did you review the documents entitled admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, Your Honor.
And each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
We are.
That's anything you wish to say on behalf of your client?
We'd ask the court to follow the plea agreement. But Mr. Ortiz has a large family and a loving family. They want him back as soon as possible.
All right. And cause number ending in 6-8. The court will follow your agreement, sentence you to 14 years in the prison, give you credit for any time served. There's a $5,000 fine concurrent with 2025 CR 003667. Taking consideration 2025 CR 000621. And there's to be no residing with minors. And cause number ending in 6-7. As previously stated, the court is finding you guilty. The court is going to sentence you to 14 years in the prison, give you credit for any time served. There's a $5,000 fine. This will run concurrent with 2025 CR 003668. Taking consideration 2025 CR 000621. Did you review the document entitled Trial Court Certification? Also, no residing with minors. Did you review the documents entitled Trial Court Certification with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because these are plea bargain agreements, because I followed your plea bargain agreements, because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Let me ask you something. Do you have any children?
I do, Your Honor.
What are their ages?
All of them. One's 26, the other one's 25. I have an 18, a 17, and a 16.
And a 16-year-old. So,
2 grandkids.
and 2 grandchildren, what are their ages?
One is 5 and the other one's gonna be 2.
Okay. Well, let me ask you something. So these drugs, methamphetamine and heroin, how would you feel if somebody in the chain of selling drugs, hey, I'm just doing this to make some extra money. How would you feel if they ended up with your grandchildren or your children at a party and introduced that drug to them?
I would not feel good at all.
So what you were doing, that could have easily ended up being filtered down to your grandchildren or your children. This whole fast money thing that people are so apt to do, you cannot build your happiness off somebody else's misery. And I guarantee you, if you made any money from this, you probably don't even remember where it went because it wasn't earned correctly. Do you understand?
I understand.
So when you're sitting at the prison, you need to think about your children and your grandchildren and what kind of world you want them to have. And do you want this to be the world? And I read the police report where there are all these drugs in a house and there's a 12-year-old in there and people saying they love their children. No, you don't. Because if you did, there would not be a 12-year-old when you have all these drugs in the house and they could have easily got into those drugs. And I'm sure those drugs stink to high heaven. You understand?
I understand.
You're going to have to do better. All right. Good luck to you. Thank you, Counsel.
Thank you, Your Honor.
I can't say as I disagree with her, but let me know in the comments if you think differently. All right, now we'll go to Judge DeSanto, now that we got to watch that, and I'm all bandaged up now from Ellie. Crazy cat.
I'm sorry, Counsel, how much does Ms. Looney owe?
She owes $3,600 in rent, and there's other including utilities and some late fees of $4,903.93, plus $84 in costs, with the total being $8,587.93.
Okay, what are the other costs that you're referencing?
No problem. It's late fees and utilities. The landlord pays all the utilities and was supposed to be reimbursed by the tenant.
Okay, and how much are late fees?
I have them combined. Dr. O'Neill, do you have that number?
The balance with no late fees is 88,260. Late fees as of today, 2,250. That brings the balance to 10,510. But with just utilities and just rent,
$2,250?
well, it's just the agreement was $25 a day, and that's how long it's been. So even if we waive those and we're just talking about utilities and rent, we're at $8,260.
So how much are the utilities, Dr. O'Neill?
No, excuse me. I'm on the late fees. I'm not on the utilities right now.
Okay.
Did you say $25 per day?
That was the agreement if you were late. But like I said, I'm not really worried about that. The utilities and the rent are $8,260.
So if somebody was 1 month behind, that's $750 in late fees.
That's what the lease would say, Your Honor.
I understand that. The court does not find that that's equitable at all, and the court is not going to order that amount of late fees.
We offered to waive everything, Your Honor. We just wanted
Tell me how much the monthly rent is, please.
$1,200.
$1,200 per month. When's the last time Miss Looney paid rent?
February of 2025.
Okay, so March, April, May is $3,600. Okay? And so what are the utilities?
In February, it was $1,606.29. In March, it was $1,248.72. In April, it was $923.92. And May, it was $881.40, bringing the total of $4,660.33.
Is this a business?
What's that? This is a house next door to a business, and this is not something I'm not a typical residential landlord. We are trying to help Miss Looney out.
Like what, $1,606 for utilities?
It looks like in February, yes, and it continues to go down.
Dr. O'Neill, explain what utilities that's included in the 1,600.
That is gas, electrical, water, internet. I guess all of the Wyandotte municipal. But yes, that's correct. And it looks like that's the highest one ever that we've ever had. And they're mostly, we're averaging closer to the 1,000 range. Like it went down to 1,200 the very next month, 900 the next month, 800 the next month. So it looks like that was the most gas, perhaps. I'm not certain, but yeah, that's the highest one we've ever had.
Well, that's why I was wondering if it was a business, because I've never seen a $1,600 utility bill, even with all those.
Like I said, that was internet, electrical, gas, and water combined.
I understand that. I understand that. Did you provide copies of the invoices to Miss Lee?
Yes, always.
And so did you, counsel, did you attach any of those to your complaint, please?
I did not, but if you would like us to do that, I guess
Miss Looney's had every bill, and we've even offered previous bills from future years that she could look at to compare. I agree. It does seem high, but I also, it is what it is. I mean, I can't control the utility bill.
I understand that, but was there any investigation to determine if there was a leak or somehow bills got combined with something? I mean, I've never seen a house. That's why I was asking. I'm not suggesting that that's not the bill you received. But again, that's what I thought maybe been a business. So Ms. Looney, why did you stop making your payments?
I had fallen behind because of Christmas and I was a single mom at the time. I have 3 kids and Mike had told me as long as I caught up on everything that I would be good to stay here. And he said he was selling the place and blah, blah, blah. So I borrowed the money from my dad to get caught up. And, as soon as I got my taxes, I had to give him everything that I had for my taxes. And then, he proceeded to tell me that the lease, as soon as the lease was up, I had to move. So I'm 7 months pregnant, I have 3 kids, and then I'm a waitress, I have no credit. I started freaking out because how am I gonna get into somewhere else? Because everywhere I've applied to, you have to have at least a credit score of 610 or to 650. So I'm like, I can't pay the bills here because my utility bill alone is insane and have the money to move out.
Okay, well, ma'am, okay, you got behind because of Christmas. Well, I can understand that you have kids and there's Christmas, but, you know, perhaps
And my
Christmas.
utility bill was
Excuse me, I'm
crazy and
speaking.
I've frozen this
Excuse
house
me,
all
I'm
winter.
speaking. Ms. Looney, I'm speaking. Please do not interrupt me while I'm speaking. But perhaps Christmas needed to look a little bit different if you didn't have the funds to make your rent payment. Is your $1,606, is that February utility bill, does that include any past due amount?
No, it does not. And I have told Mike multiple times during the winter time that the house was freezing. So I'm paying $1,200 and me and my kids are freezing in this house and nothing was investigated, nothing. I sent him the thermostat. I'd have my thermostat on 70 something and then it would be 50 something degrees in my house.
So did you have anybody come out to look at the issue?
Did I have anybody come out?
Yes.
No, because the utility bills were not allowed to be in my name.
So did you ask your landlord to have somebody come out?
He told me to get stuff to put on the doors to block the stuff from
That was my
coming.
question.
No, he did not have anybody come out.
Did you ask your landlord to have somebody come out?
I did not specifically say, can you have somebody come out? I had told him that the house was cold multiple times.
Okay, well. Perhaps you should.
I've
You should
fixed
have somebody
anything.
come out to check it out, see what was going on. Yes, Mr. O'Neill?
I just was saying, I'm happy to bring anything up to speed that was insufficient. I always have and happy to. She was welcome to call anyone she wanted at any time. She called me for a plumber thing once and I said, I don't even have time to fix that. It sounds like it's just the guts. If you could have somebody replace that, I'd be happy to cover the cost of the labor and the materials. There's just wasn't great communication on that. And I think probably not great maintenance on your current like thermostat, furnace, or windows, or whatever it is that's causing this high fee. But like I said, I don't have any control over the utility bills, and would have been happy to help. I helped her for years. There was consistently late payments since early on in this relationship, and I've always waived late fees. I've never, to this day, charged a late fee. I've always let things go until they just build up. And she had her dad kind of pay off about $5,000 worth of late fees, or not late fees, but just rent and utilities. And then I said, we couldn't let this happen again. It immediately started happening again. I said, we're going to have to end this relationship. And
When you say relationship, Mr. O'Neill, when you say relationship, do you mean landlord?
I mean, this rental relationship is a renter. I can't have this renter. It can't have you here anymore. I'm sorry, but we have to receive payment. We can't, and we've been continuing to pay all these utilities. So all these payments you're seeing at $46.60, we've covered those. I've just paid those personally just to keep them on.
Can I say something, please?
Yes, Ms. Looney.
I did not fall behind again until he told me I had to move out. So that is false. After my dad helped me pay that and I paid him back with my taxes, I paid every month after that and did not fall behind until he told me that I couldn't live here anymore. And then I didn't understand how I was supposed to make those payments and pay for somewhere else to move into.
Ma'am, I can assure you of this. Even if you have somewhere else you need to move, you don't get to live there for free.
I understand that, but had he let me have the utility bills in my name, I could have gotten help from the state as well for that, my utility bills being more than my rent. I can't get help when they're in his name.
She never asked, not even a single time
Like,
to have her
before I
utilities in
moved
her
in,
name.
I did, and you told me that I couldn't, and I don't even want to say on the record why you told me I couldn't.
You're more than welcome to say anything you want here.
Okay,
There's
because
just
you
not-
didn't
that's just
want the
not the
city
truth.
to know that you were renting the house out to me.
It
That
was,
was like an undercover thing.
it was not an undercover thing. There's not one thing
Like,
that's
you, I
completely.
have text messages
Hold
of
on,
you
hold
telling
on,
me.
boys. I'm not having this back and forth on my record. Not having this back and forth on the record here. So I'm going to say this, that the amount due and owing without late fees is $82.60. The court will order $75 per month for late fees. The court's not doing $25 per day. And so that's March, April, and May. That's 3 months worth. So that's $225. So it's $8,485. And how much are the court costs, counsel?
$84.
So the court's going to order $8,569 is what's due and owing. The court does not have any, there's not a legal basis to why this court should not enter this judgment. Ma'am, you do understand all of your rights that you've received in your packet of information, correct?
Yes, I believe so.
Okay, did you read those? Well, you know, you have the right
Yes,
to.
I read it before I got on here.
Okay, and so you understand you have the right to request rental assistance, you have the right to have an attorney, and that you have not availed yourself of either one of those, correct?
Correct.
Okay, and you're not looking for any of that, is that also correct?
Correct.
Okay. Okay, well, the court's going to then indicate after hearing judgment to enter the amount of $8,485. Writ date
June 10th.
June 10th.
Judge, I
Wait,
know
so I have to pay $8,000 by June 10th? Is that what you're telling me?
if you want to stay.
Oh, no.
Okay.
What do you
Judge,
want to say, counsel?
can you, I know the rent, can you give me the numbers again for the utilities that you're approving so I can get to the right number when I put it in the judgment?
So $1,200 per month for rent.
Yeah,
3
that I
months,
got.
Which is $3,600. Counsel, I'm making a record, so I'm going through the whole thing.
Sorry.
$1,200 per month for rent. 3 months has not been paid. March, April, and May, so that totals $3,600. $1,606.29 for February utilities. $1,248.72 for March utilities. $923.92 for April utilities. $881.40 for May utilities, for a total of $4,660.33. Plus late fees of $75 per month for March, April, and May, totaling $225, and then the $84 in court costs.
Thank you.
You're welcome. And was there personal, did you request a money judgment, counsel?
I did not.
Okay, so no money judgment. All right, the court will note after hearing that plaintiff is entitled to recover possession of the property. Amount now due and owing for unpaid rent and other costs is $8,485. No, I'm sorry, $8,569. that previous amount was without court costs. If that was paid or defense settled out on before June 10th, plaintiff applies for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant, and no money judgment will enter at this time. The court will send it upon receipt. Good luck to you.
I
Thank
can't, hold on, I'm not, so what's the date I have to be out? I can't hear you.
June 10th.
Okay, and then the court costs and stuff, how do I go about doing that? On a payment plan or something?
No, they're not paid to the court, they're paid to the landlord. The amount that's due is paid to the landlord.
Because that was already paid.
Okay, so I worked something out with him?
Yes, if you want.
Okay, and then if I don't?
He'll have to file a separate action to collect the money from you.
Okay,
Okay?
yep.
All right, good luck to you all. Thank you.
Thank you. All right.
Okay.
That is a big old hole that she is never going to dig her way out of, in my humble opinion. Let's go back to Judge Boyd.
Good morning.
Cindy, I'm gonna work out something where I can actually see you over there.
Okay, go ahead.
All right, court is calling 2022 CR 7965 State versus Fabian Rodriguez. Can I have parties announced for the state?
Jason, you're here for the state, Your Honor?
Defend-
Leal for Mr. Rodriguez, Your Honor.
And are you Mr. Rodriguez?
Yes, Your Honor.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
I don't have a trial court certification on this.
Judge, I confer with the prosecution and they are requesting a reset because there is some felony spending and we would like to have this matter like wrapped up all with the case pending, close this MTR.
Sorry, Judge.
No problem.
Yeah, so on this one, I did look at it. The defendant has two new number ones that are alleged, and one of them is a felony that just occurred on April 24th of 24. It's unindicted currently. I did look at it and we do have some discovery, but we are missing quite a bit of discovery. And so I've reached out to the intake prosecutor so that we could confer before the next setting and try to get a global offer to resolve all of the cases.
Okay, and that alleged offense, that's not a drug case, is it?
No, it's a collision causing injury.
Okay. All right. Ms. Ferguson, what date did you give him for his sentencing on this client?
I believe June 13th.
All right. State, will you need it extend?
Oh, 12. I'm sorry.
Okay. All right. State, do you need this case extended past that?
I can't say for sure, Judge, but I believe that should be sufficient. I've reached out to the intake prosecutor already, and they'll reach out to the agency.
All right. Since you're already going to be here, we'll set it for the 12th. And then if the state needs some more time and there are no objections, then we can always reset it.
That'll work.
All right. So that will be June 12th,
Thank you.
2025. All right. Thank you. Ms. Abrams, he's being reset for June 12th.
Let's go back to Judge DeSanto.
I just request you to unmute and turn on your camera. So can you please unmute and turn on your camera and tell me your name, please?
Hello, my name is Xtavia Edwards.
I have you. No, individual that is sitting on the bed in a tank shirt. What is your name, please? The individual that just logged in, what is your name, ma'am?
I'm sorry, Tankia Hilson.
Okay, ma'am, you're in court, correct?
Yes, ma'am.
Okay, then you need to dress appropriately for court because what you're wearing is not appropriate for court. So please dress appropriately, and then I'll put you in a breakout room with the attorney when she's done with the other matter.
Okay.
So, Ms. Whitney, I'm going to put you in a breakout room 1. Ms. Edwards, I'm going to put you there as well.
Thank you, Your Honor.
Okay, let's go on the record in the matter of the City of Wyandotte versus Josiah Zavala, 25754 A and B. And counsel, your appearance, please.
Your Honor, good morning. Richard T. Serrano, P33828. Today, Your Honor, I appear as MIDC counsel on behalf and with my client presently in custody. And also, Your Honor, for arraignment purposes, I've advised him of the nature of the charges against him. He understands all of them. He also has been advised of his rights. He understands those. So we wish to enter a plea of not guilty, waive formal reading, stand mute, enter a plea of not guilty, please.
Okay, thank you. All right, and Mr. Zavala, your name for the record, please.
Josiah Zavala.
Okay, thank you. Ms. Hudson, did you put on a bathrobe? Hold on, let's go off the record for a moment. Ms. Hudson, please sit on mute. Did you put on a bathrobe?
I have a jacket.
Okay. All right, let's go back on the record in the matter of Mr. Zavala. The court's going to enter, waive formal reading, enter plea of not guilty on behalf of your client. Schedule this matter for pretrial on June 11th.
10:45.
At 10:45 a.m. And counsel, I asked you bond.
Your Honor, my client tells me that he was arrested last night. And Your Honor, they've impounded his vehicle, which he just got. He has a lengthy criminal history, Your Honor. Some is non-public, but he tells me he's not on probation or parole and has nothing pending at this point. He tells me he's never failed to appear in court for any of his matters. And he's most concerned with, he has a son. He lives with the child's mother and himself. The son's age 5 and he has twins on the way. So he just got a pretty good job working landscaping, Your Honor, and he wants to keep that job. We would hope the court would consider that he's no warrants pending, and he's 33 years old now. He's trying to be a little more responsible than in the past. We'd ask for a personal bond, Your Honor, a bond you reasonably expect to post under the circumstances. Thank you.
So, Mr. Zavala,
Yes, ma'am.
where is it you work?
I work for a landscaping company that does private landscaping for like the union and whatnot, the union hall.
Yes, sir. It doesn't tell me the name.
Rough Brothers. That's the last. Rough Brothers.
And what hours do you work, sir?
I work from the morning around 8:30 until about like 6:30 at night. Well, in the afternoon.
I've not heard of it. It doesn't start till 8:30 in the morning, but okay.
I just started that job 3 days ago.
All right, and prior to that, where did you work?
I worked for TLC transporting vehicles for Ford.
For the who?
I was transporting vehicles for Ford.
Oh, Ford.
Yeah, I'm waiting to get back in there.
And so, sir, if you were to test today, what's in your system?
I'm sorry, man, what?
If you were to test today, what is in your system?
Marijuana, as far as I know, ma'am.
Anything else?
Nope. Or for me to be like Keith's job, I had to test for it.
When's the last time you tested, sir?
Last week. I actually got tested today.
Well, the allegations are sir, that you had methamphetamine and cocaine in your possession. Are you out on bond in any other jurisdiction, sir?
No, ma'am.
And you're not on probation or parole anywhere?
No, ma'am.
All right, well, given the nature of the charges and the a lengthy criminal history, some of which is what you're charged with, sir. And to protect the safety of the public, the court's going to order a $3,500 10% bond. In the event you post bond not to possess or consume any alcohol or drugs that are not prescribed, and you'll have to participate in random testing. So after you post bond, sir, you are to report to the 27th District Court Probation Department. So you can get your testing information.
The bond on A and B or just A?
Just A, oh, it'd be the, B also listed here. Oh, yes, yes, okay, so that's count A. Is the bond. Okay. Good luck to you, sir. We'll see you back on June 11th. Thank you.
Thank you, Your Honor.
And this is.
Let's head back to Judge Boyd. By the way, if you want me to go into overtime today, put a 1 in the chat and we'll add some extra time to the stream.
Carrillo for Mr. Spiller. And are you Mr. Spiller?
Yes, sir.
All right. Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, sir.
Are you the same Christian Spiller who's placed on community supervision in 2017 CR 13755 for the offense of possession of a controlled substance, penalty group 2, 4,200 grams on September 27, 2019 for a term of 3 years? Is that you?
Yes, sir.
All right, state.
Judge, on the supplemental.
Oh, I'm sorry, did you review the supplemental with your attorney? Did you understand it?
Yes, I did.
All right, you may proceed.
Thanks. Violated. Violated.
Oh, you okay?
Yes, sorry.
Mhm.
Violated condition number 5, in Bear County, Texas, the defendant, Christian Spiller, then and there failed to report to the supervision officer as directed for the months of November, December of 2020, January, February, March, April, May, June, July, August, September, October, November, December of 2021, and January, February, March, April, May, June, July, and August of 2022, violation condition number 5.
How do you plead to that, true or not true?
Sure.
And Your Honor, will waive the remaining violated conditions.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, sentence you up to 4 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there proposed agreement?
Yes, there is, Your Honor.
And what is that?
It is to revoke the individual office probation and reform the underlying sentence of 4 years to 2 years in the Texas Department of Correction.
Are you asking the court to follow that agreement?
Yes, sir.
Are you waiving your right to appeal?
Yes.
Court will follow your agreement. The court will revoke, sentence you to 2 years in the prison, give you credit for any time served, and there's to be no residing with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, then you need to speak to an attorney. Do you understand?
I do.
All right, we can go off the record. I'm going to request therapeutic community for you. It's to help you with any drug issues you may have. You understand?
I do.
All right, good luck to you.
Thank you.
Thank you, Honor. Thank you. Yes.
On Mr. Rodriguez, Judge, the case that was before you, this morning. It's an MTR and he's remanded with a bond, and we're asking that the court set a bond on that case.
All right, just give me a second. Let me finish this up and I'll take that up.
Was this bond? Was there a bond?
Yes.
Let's head back up to Michigan, Detroit specifically, but we're going to pay a visit to the 36th District Magistrate Court.
All right. Wait. Oh, there's Bill Reagan. Okay, we're ready to go. All right. Morning, Mr. Reagan.
Hey, Judge, how you doing this morning?
Okay, fine. Thank you. Yourself?
Outstanding.
Yeah. Okay, sir, at DDC, your name, please. Good morning.
Must be good.
Anthony Simpson. Okay, all right. Hello, Mr. Simpson. Let's see. Are we ready on Mr. Simpson, both parties? He has some tickets first, though.
Yep, give me one second. Yep.
Okay. Mr. Vincent, he does have some tickets. I'm gonna address those first.
Thank you, Magistrate.
Okay, so. All right, good morning, Mr. Ron.
Good morning, Your Honor. How you doing? How's everyone doing? Happy Friday. Good to see you, Mr. Vincent.
Yes, sir. Good to see you as well.
Okay, so I'm gonna do Mr. Simpson's tickets first, okay? So, Mr. Simpson, because you failed to appear for, looks like a couple of court hearings, there were bench warrants that were issued. The court's gonna set those bench warrants aside. You do have the right, oh, hold on 1 minute, everybody.
I'm gonna sign off, Your Honor. I'm gonna give Mr. Vincent a break this moment.
I appreciate that. Thank you.
Mr.
Not much of one though, because you got your, homework. Yeah.
Okay, we'll start over. All right, so Mr. Simpson, because you failed to appear for some court hearings, there were bench warrants that were issued. The court's gonna set those bench warrants aside. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. The court is calling ticket number SP 1479473. Date is 8/5/23. You're charged with driving with license suspended. Ticket number SP 16111549524. Charged with no insurance, and that's it on that one. Ticket number SP 1622951911224. Charged with improper plates, driving an unregistered vehicle, and failure to display a valid operator's license. So for those charges, you could face up to 93 days in jail and or receive a fine in the amount of $500. The court is going to enter a not guilty plea on your behalf, set a personal bond, and you have pretrial date. Looks like June the 4th at 9 o'clock. And that will be before Judge Archer, okay? And that's by Zoom.
Thank you.
All right. Okay, so wait a minute, we're gonna move on to your main case. Can you restate your name for the record? All right, the court is calling case number 25057890001. The people of the state of Michigan versus Anthony Dejan Simpson. May I have your appearances, please?
Magistrate, good morning. Always a pleasure. Mr. Murad, Steve Vincent for the people, P71917.
And good morning, Your Honor. Ryan Murad, PA 3665. On behalf of Mr. Anthony Simpson, we waive the formal reading and stand mute. Mr. Simpson's been advised of his rights.
Okay, then thank you. Good morning to the parties. The court will enter a not guilty plea on behalf of Mr. Simpson. By recommendation, Mr. Vincent.
Magistrate, it doesn't take much here to see that this defendant is a danger. He put 2 bullets in his brother one in the, I guess, the upper chest, one in the back, is a direct result of that brother who's a victim in this matter being involved in a homicide shooting regarding this defendant's friend. This defendant's been ID'd. Yeah, this defendant's been ID'd as the shooter. He's a clear and present danger at the highest degree. Right now, it's an incident that just took place a couple of days ago. Respectfully, we're asking for a $250,000 cash surety. We're also asking for a tether as well as home arrest.
Okay, your response, Mr. Moran?
Judge, on behalf of Mr. Simpson, he's 31 years old. He's a life resident here in the state. He indicates, Judge, that he's gainfully employed here with the city of Detroit, Department of Transportation. He's been there for about 3 years. Judge, he works Monday through Friday. Despite his gainful employment, he still falls within the guidelines, is not able to post a monetary bond. He has 3 children in the community as well. Obviously, the charges are serious. A few things that I think go against the likelihood of conviction here. One of them being that it doesn't appear that any firearm was located. I'm looking at the last paragraph of the investigator's report. Obviously, this seems to be an offense that would be isolated with family. But importantly, I don't know of any priors. I think there's a larceny that he disclosed to us, but I don't think there's a violent danger or any sort of pattern as more so opposed to an isolated incident. And I think given that there isn't this, ongoing issue going on, I think you can craft the bond here to benefit Mr. Simpson and the complainant, being his brother. I would ask the court to consider a GPS tether and a house arrest bond.
Okay, thank you. Okay, so the court has had an opportunity to review the investigator's report as well as listen to the arguments set forth by both parties. Mr. Simpson, the court appreciates the facts that you're working and taking care of your children, seem to have stable employment. But the nature of these particular charges are very, very serious. Does seem to be a family related incident. So I don't know that there's danger to anyone else. It's definitely a danger to the complaining witness, your brother, Mr. McGee. And I can appreciate the fact that no weapon was found, but somebody was shot. Mr. McGee was wounded, shot in the shoulder, in the back, and then I believe there were also shots discharged at a vehicle. And he poses a definite danger. He has some serious charges, one in which he faces up to life. I don't see that there no prior convictions, Mr. Vincent.
Defense counsel is correct. I have that larceny in 14, nothing other than that.
Okay. All right. But the court does feel that based upon the allegations by clear and convincing evidence that Mr. Simpson does pose a danger to specific individual, Robert McGee, his brother. Possibly, I know there was another brother that was involved in this melee. So the court will set a cash surety bond in the amount of $150,000. And Mr. Simpson, if you post bond.
Judge, I'm sorry, if I may, Mr. Simpson, this isn't end all be all, Mr. Simpson. You're going to see the judge in 2 days. You'll have another shot at arguing bond. This doesn't mean that this case is going to go forward. It's still very, very early. Hang tight, stay strong, and let's focus on what the magistrate's saying. Okay, sir? Come on now.
All right, Mr. Simpson. You okay? All right. Do you want us to recall your case or are you ready to move forward? Okay. Recall. Okay. All right. We'll move forward then. We'll be done shortly. Mr. Moran, I was going to ask you about his work hours. What hours does he
6 a.m. to 2:30 p.m. Monday through Friday, Judge. I just asked for an hour each way.
Okay. So if he posts that bond, then the court will allow him to go to work back and forth. So he'll have curfew. That will be 6 o'clock PM to 4 AM. Perfect.
Unfortunately,
give this-
unfortunately for the defendant, once the employer finds out he has a suspended license, he works for the Detroit Department of Transportation. He actually drives. He can't even do that. But I mean, I digress.
Okay, yeah, I don't see that on here, but that's, something he could take up with this.
Don't say anything, sir. Don't
employer.
don't say anything. It's okay. It's okay.
Okay, I don't see that as a charge. That might be something, but he could take that up with his employer.
Sure.
He has to post a bond first.
Right.
All right, and then that's unaffordable, Mr. Murad, you've indicated?
Yes, Your Honor. It is.
So there'll be a bond redetermination hearing set for Monday. That will be June the 2nd. And that will be at 9 o'clock AM before Judge McConical or Judge Williams. He does have 2 court dates. He has a probable cause conference that's scheduled for June the 6th at 8:30. That'll be by Zoom before Judge Jefferson. Then he has the right to a preliminary examination. That's scheduled for June the 11th at 8:30. And that will be in person before Judge Jefferson. Now, so you do have a couple of bond conditions. You may not possess or purchase a firearm or any other dangerous weapon, and you may not have any contact with Robert McGee or Broderick McGee. Is that understood? Okay, all right then. That concludes this matter.
Thank you, Your Honor.
Okay.
I'll figure it out.
Mr. Murad, you're already winning, man. You're already winning. You're 1-0 already.
I don't know about that.
I'm sorry. Oh, I thought the court said.
Parnell. Go
Court, doesn't matter if we go out of order and take one of the females.
Okay, it's audience choice time. We can either continue to ride here in Detroit, or we can go to Florida where Judge Brantley Clark is doing his first appearance cattle call. Put a 1 in for Detroit, a 2 for Florida. I'll give you a minute or two.
No, I'm sorry. Oh, okay. Oh, anybody have one? Okay, hold on. There's curfew hours in here. Okay. Okay. So we have Mr. Purnell. Good morning. Mr. Purnell has some tickets, so I'm going to address those first. Mr. Purnell, because you failed to appear on some court matters, there were bench warrants that were issued. Court's going to set those bench warrants aside. You do have the right to remain silent. Anything you say can or will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. The court is calling ticket number SP 1057386. You're charged with driving an unregistered vehicle, improper plates, and driving no license suspended. Ticket number SP 1329494. Charged with driving with license suspended, improper plates. Ticket number SP 1350376. You're charged with driving with license suspended and driving an unregistered vehicle. Ticket number SP 1617679. You're charged with failure to display a valid operator's license. Ticket number SP 1634380. You're charged with driving with license suspended and no insurance. Ticket number 400408. Charged with no operator's license, no insurance, and unregistered vehicle. Ticket number 440202. You're charged with no operator's license.
Ticket number SP 1331193, charge of driving license suspended, unregistered vehicle and improper plates. Okay, sir, for those particular charges, you could face up to 93 days in jail and or receive a fine in the amount of $500. The court's gonna enter a not guilty plea on your behalf and set a personal bond. You have a pretrial that's scheduled for June the 23rd at 8:30. That will be before Judge Ramsey Heath. And that will be by Zoom, okay? All right, can you restate your name for the record?
Marcus Burnell.
All right, the court will call case number 25057-89201. The people of the state of Michigan versus Marcus Martez Purnell. Appearances, please.
Good morning, Lisa Coyle, appearing on behalf of the people.
And Ryan Murad, PA 3665, on behalf of Mr. Parnell, we waive the formal reading and stand mute. Mr. Parnell's been advised of his rights, and good morning, Ms. Coyle.
Good morning.
Okay, thank you. And good morning. The court will enter not guilty plea on behalf of Mr. Purnell. Ms. Coyle, do you have a bond recommendation?
My bond recommendation is a $250,000 cash surety tether house arrest, Your Honor. These are extremely serious charges in which, based on the brazenness of the defendant's actions, this is a case in which I believe that, based on the allegations and past history, it appears that the complainant is in danger. She's very fearful for her life. I've spoken to the prosecutor's office regarding this matter. This case was captured on video at a mini mart, in which backs up not only what the complainant says, but there's another witness there that was the clerk, that he observed the assault. He observed that the Mr. Purnell chased the complainant into the mini mart with purse and the gun openly in his hand. He assaulted her repeatedly in the mini mart, that he punched her in the head with a closed fist. He allegedly grabbed her by a hair, threw her to the floor. He also then, while in the mini mart, took her purse while armed. He's armed with that gun, and then they leave. He forces her into the rear passenger side of the car. Per the complaint, she tried to get out of that vehicle. He grabbed her and he struck her again with a closed fist. There's also allegations later at the hotel that what began as consensual fellatio turned into something else, but I'm not going to address that because that at this point is not charged here. This is a 3-year dating relationship. The officers did search the defendant's car. A gun and ammunition was recovered. This was allegedly over an argument that began where he was seeing another woman. I do know a prior assaultive contacts, which began on October 4th of 24. Officers brought a warrant to the prosecutor's office, same victim, for aggravated assault. They were unable to contact her. On March 14th of this year, again, for domestic violence, unable to contact her. We have April 7th, as recent as April 7th, same victim for assault and battery, also unable to contact her. Your Honor, this is a typical, unfortunately, a domestic violence relationship in which this is escalating to a point that he openly is assaulting her with a gun in front of others and on video. Your Honor, this woman is in fear for her life and should be, based on the allegations brought forward. Your Honor, people are asking for that high cash surety bond in order to enable her to be safe. We're asking for that $250 cash surety and a tether house arrest, no work. If he is able to get out on that bond, the fact that he can come out of his house should not be happening, whether he's working or not. This is such an assaultive allegation, Your Honor, that this is a situation in which the complainant has had repeated assaultive contacts with the complaint or the defendant, and that the people believe she is in danger for her life. So for those reasons, I'm asking for that cash surety bond, of course, with no contact. Thank you.
Thank you. Ms. Moran.
Thank you, Your Honor. So I'm going to start backwards here, Judge. I ran the register of actions under Mr. Purnell, and I didn't find anything that ever amounted to a charge of any sort of domestic violence or assault. So it sounds like there's an alleged reports, but there was never probable cause established for those reports to turn into charges, as is the standard that's required by law. Additionally, Your Honor, if you're presumed innocent of the crimes you're charged with, I think you're presumed even more innocent of the crimes that you're not charged with, allegedly. On behalf of Mr. Purnell, there's a few things in this report that I'd like to highlight. I mean, when it comes to prior criminal history, I don't think there's anything besides an old marijuana case. Also, if there was a firearm recovered in the car and he wasn't charged with CCW, that tells me he probably has a CPL, which tells me that he doesn't have traffic warrants. That tells me that he doesn't have any convictions that's prohibiting him from having that within the 3 or 8 year requirement. Now, a few things I want to highlight here that, you know, the story, when you start to read it, it's easy to just kind of fall in and think my client's this danger, this, you know, evil person with unlawful imprisonment charges and things of that nature. But, you know, this is a complainant who's texting my client to come and pick her up. Who then is hold on, sir. Who then is asking to, you know, be taken to the liquor store. Then they go to the liquor store. Then in the police report, the complaining witness is saying she doesn't remember what happened after the liquor store. So I don't know if that complainant's under intoxicant. I don't know why the complainant doesn't remember that. Now there is a described assault, right? But let's really kind of comb through this described assault with a fine comb. Now they're saying that a firearm was in his hand and he was seen striking her and chasing her. Never saying that the firearm was pointed at her. Never any shots going off or anything like that. And then after this alleged incident that's described as this horrible scene, they're at a motel room where there's, you know, as indicated by the people in the beginning at least, consensual fellatio. So is this a serious, dangerous guy who's unlawfully imprisoning people, or is this maybe a toxic relationship that a no contact order and a GPS tether can solve? You know, the injuries described in the alleged assault, I believe would not amount to the great bodily harm standard, just based on the injuries described. It's not alleged that he hit her with a firearm. That has not been alleged. So really, this is a DV case, and the FA comes in because there's an allegation of a firearm in his hand. I do think the great bodily harm and the unlawful imprisonment is a bit of an overcharge. But given his lack of real prior criminal history, and I hope the court's not considering anything that wasn't ever charged, but given the lack of criminal history, given the fact that these parties will stay away from each other and don't share a residence, I think that you can do something here, Your Honor, to make everybody happy. Give him a GPS tether house arrest. He can't leave his house. He can't get near her no matter what, even if he can't work. That's what I'm going to ask you to do, Judge, based on the lack of criminal history. And really, because of I would say there's two sides to every story, and there's not the highest likelihood of conviction for at least the top 2 charges here. So for those reasons, Your Honor, I'm asking for you to do a personal bond and the GPS tether with home confinement.
I'm going to briefly just respond to that. I did check that there is no CPL. He has that delivery case, and that was from 2017.
You got an echo.
I heard an echo.
You know what? That's on my end.
Oh, okay. Go ahead, Ms. Cole. You started breaking.
Okay, I did check. He does not have a CPL. He does have a conviction. His rights to carry a weapon were not restored. Your Honor, this is the situation. This is what happens when people belittle what occurred. She went to the hospital. She had some injuries, and this is what we do: is we belittle what occurs with this woman as it's just a DV. To her, a regular assault is not. This, like I said, this is an allegation that's on video as well as been witnessed by another individual, and he was brazen enough to run into a mini mart after her. So I don't think a house arrest is sufficient in this. This is an issue whether is he a danger to the community. I would assert yes, based on that. Number 2, is he a danger to the complainant? I would assert yes, for sure. This is the 4th allegation. And I know that they're not charged and he is presumed innocent on all these. But what here we are is the arguments are allegations based on, is he a flight risk and is he a danger to the complainant and the community? And this is not whether there are previous contacts with this same complainant that from before. They can't be made up. This is going forward. So she has made those reports. She may not have followed through. Typical domestic violence, but this is unfortunately the cycle of violence of control. And the fact that he felt that he had to chase her into the mini mart with the gun. When she got in the car, I do note that the gun was on his lap. That is showing obviously control over this woman, that he's going to assert his power and control. It appears later in the IR, she makes no bones about it. Their relationship is based on hanging out and having sex and drugs and so forth. And so, but this is what it's about. And I don't want to use the word pimping out, but that's what he appears to be. This is the way he operates with her, and she understands it. So for these reasons, Your Honor, I do believe that he is a danger. And I would ask for, even if you gave him a tether, no work, only house arrest. This is not a case that is personal bond would be adequate for.
Okay, thank you. All right, the court has heard the arguments, and just FYI, Mr. Murad, count 5 of the complaint. There is a DV charge. It's on the second page. You may not have observed that. So
no, I'm not disputing that, Judge.
Oh, I thought you said it was no domestic violence charge. But anyway,
no CCW charge.
Okay, I
But
heard
never
that
mind,
one
it's
as well.
moot.
But nevertheless, and it wouldn't matter if it was a CCW or not. You know, because having the ability or license to carry a weapon doesn't mean that you could use it in any manner, especially in a assaultive manner against someone else. So with that, the court is going to find, based upon these allegations, that there's some slapping and kicking and punching and striking with the handgun, and that the
Judge, that wasn't
witness, I believe,
alleged. I'm sorry,
end
Judge,
up at,
that part wasn't alleged that he ever hit her with a gun. It was only, that was never alleged. It was only alleged that he had a gun in his hand.
She ends up at the hospital. Okay, so the court will strike that then if that's not, but I saw that. Says the complainant states the defendant struck her in the head with a handgun. I thought I read that.
Yes, he did. I saw that same thing.
Okay. All right, then that's okay. That's on in the second, third paragraph of the IR, Mr. Murad.
I was basing off the video. The video was described, wasn't described in the video.
Okay, that was a statement that was mentioned. So the court was correct in that regard. But you know, we all want to make sure we get the facts straight, irrespective of how we interpret them. You know, the court is not here to make a decision on his guilt or innocence, but the court is here to set a bond that, in fact, protects the community, claiming witness in this particular instance more so, and that one in which Mr. Purnell will appear back in court. So the court does find by clear and convincing evidence that being on video, the weapon, the striking in the head, that there's a cash surety bond that must be set. Court will not set it at $250,000. I think that's high. The greatest charge that he's facing is a 15-year offense, although they're all extremely serious. Certainly there could have been some added charges. They were not, and the court is not going to take those into consideration. The court will set a $75,000 cash surety bond. And Mr. Purnell, sir, if that bond I don't recall seeing anything relative to work. Okay, the court is going to impose a tether, but it's a no contact tether. It's not a stay-at-home tether. And also there's a condition, Mr. Purnell, that you not have any contact with Raven Smith, and you not possess or purchase a firearm or any other dangerous weapon. Is that affordable or unaffordable?
Unaffordable, Your Honor.
Okay, then there'll be a bond redetermination hearing on Monday, June the 2nd, before Judge McConnell or Judge Williams. He has 2 court dates. He has a probable cause conference that's scheduled for June the 10th at 8:30. That'll be by Zoom, Mr. Purnell. And then you have the right to a preliminary examination. That's scheduled for June the 17th at 8:30. However, that will be in person. Both of those matters are before Judge Duque. All right? That concludes this matter.
Thank you, Your Honor.
Thank you.
All right, we'll continue over time for one more of these. A special good morning to people watching on Rumble and X. I just took a look at the data, and today is our biggest day yet on Rumble and X. We've been streaming there for a couple of weeks now, so welcome to all of you, and feel free to say good morning in the chat over there. Let's do this one more time.
Thanks for your patience. Give us a minute, okay?
Yes, Your Honor.
All right. And sir that just arrived, your name, please?
Michael Simmons.
Mrs. Simmons. Okay, give us a moment. All right, so she's been sitting there patiently. Miss Walker? Okay, all right. I'm gonna do your case. Hold on. Okay, so Miss Walker. All right, Ms. Walker has some tickets, and so I'm gonna address those tickets first. Ms. Walker, because you failed to appear for, like, couple of cases, let's see. 4. Because you failed to appear, there were some bench warrants that were issued. Of course, gonna set those bench warrants aside. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. The court is calling ticket number SP 130-8387, 1322. You're charged with driving an unregistered vehicle and no insurance. Ticket number SP 133-0321, 32122. You're charged with driving with the invalid license. Ticket number SP 137-8888, 10422. You're charged with driving an unregistered vehicle, no insurance, and failure to display a valid license. Ticket number SX 3769504, 8/18/2020. Charged with open intoxicants in a motor vehicle passenger. Ticket number SP 1628461, 10/1/24. You're charged with driving with license suspended. So, Ms. Walker, for those charges, you can face up to 93 days in jail and/or, I'm sorry, you can, yeah, you face up to 93 days in jail or receive a fine in the amount of $500. The court is going to enter a not guilty plea on your behalf. Got a personal bond, and you have, let's see, pretrial. That's set for June the 23rd. It's like 9:00 a.m. That'll be by Zoom before Judge Kenneth King. Okay?
Yeah.
That's the dates on your tickets. So I'm gonna move on to your main case. I do need you to restate your name for the record. Okay, thank you. Court is calling case number 2505669001. The people of the state of Michigan versus Corinne Bailey Walker. Appearances, please.
Lisa Coyle appearing on behalf of the people.
And Ryan Murad, PA 3665, on behalf of Ms. Walker, we waive the reading and stand mute. Ms. Walker's been advised of her rights.
Okay, thank you. The court will enter a not guilty plea on behalf of Ms. Walker. Is there a bond recommendation from you, Ms. Coyle?
I'm recommending a 10,000 personal. I'm not aware of any criminal history before this or since this, Your Honor. This is from October of 24. So no objection to 10,000 personal.
No objection, Your Honor.
Okay, she has no priors. This is a 2-year high misdemeanor.
Not that I am aware of, Your Honor.
Okay. The court will set a $5,000 personal bond. So, Ms. Walker, that means that you don't have to post any money. You do have to appear for 2 court dates. You have a probable cause conference that's scheduled for June the 6th at 8:30. That'll be by Zoom before Judge Giles. And then you also have the right to a preliminary examination. That's scheduled for June the 13th at 8:30. That will be in person before Judge Giles in the 36th District Court. Ma'am, you understand your court dates?
Yes.
All right, then that concludes this matter. Okay, so sir, Mr. Thomas?
Yes, Your Honor.
Okay. That's Michael Thomas. I have 2 Thomases. Hold on.
Yes. Tether, is that house arrest?
No, that's not house arrest. That, which one was that?
The second.
No. On Purnell. Okay. First name is Tyrese? Because I have 2 Thomases.
Yes, Your Honor.
Okay. Okay, and Mr. Good morning again. And he does have some tickets. I'm going to address those first. Mr. Thomas, because you failed to appear for some court hearings, there were bench warrants issued. So the court's gonna set those bench warrants aside. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and if you cannot afford an attorney, one will be appointed for you. The court is calling ticket number SP 1200816 51921. You're charged with driving with license suspended. Ticket number SP 1276739 111021. You're charged with driving with license suspended and no insurance. Ticket number SP 1293000 122021. You are charged with driving with license suspended, improper plates, and driving an unregistered vehicle. Ticket number SP 1338525 41022. You're charged with improper plates, driving an unregistered vehicle, and driving while license suspended. And ticket number SP 1676709 21425. You're charged with driving with license suspended or revoked and no insurance. So, Mr. Thomas, for those charges, you could face up to 93 days in jail and or receive a fine in the amount of $500. Court is going to enter a not guilty plea on your behalf and set a personal bond. Okay. You have a pretrial that's scheduled for June the 23rd at 9 o'clock, and that will be by Zoom before Judge Ramsey Heath. Okay. All right, we're gonna move on to your main. We're gonna move on to your main case. If you would, please restate your name for the record.
Tyrese Thomas, Your Honor.
Oh,
I'm sorry.
Okay. That's all right. Court is calling case number 25056940101. The people of the state of Michigan versus Tyrese Raymond Thomas Jr. Can I have your appearances, please?
Thank you, Magistrate. Always a pleasure. Steve Vinson for the people.
And Ryan Murad, PA 3665, on behalf of Mr. Tyrese Thomas, we waive the formal reading and stand mute. Mr. Thomas has been advised of his constitutional rights.
Okay, thank you. The court will enter a not guilty plea on behalf of Mr. Thomas. So before the parties argue, it looked like it was a capious that occurred at
I
the
was still
preliminary
incarcerated.
examination.
I was never
I
free.
got you, sir. Let me do all that, okay?
I'm sorry.
It's okay.
That's okay, your lawyer, he can take care of that for you, and if you still have questions at the end, we can address those as it relates to bond or court dates. Okay, so preliminary exam failed to appear, $10,000 cash bond was set. Is this Judge Sean Jacquet? Looks like that would have been this last week, 5/19, or week before last, 5/19/25. So have we spoken to Judge Jacquet this morning? No. Oh, regarding the bond. So the court is really technically not at liberty to change the bonds that are set by the judges. It's only one judge that will allow us to call and check. So the court is going to continue that $10,000 cash bond. But Mr. Thomas, on Monday, you'll have an opportunity to go before Judge McConicle or Judge Williams for a bond redetermination hearing. Now, Mr. Murad, I guess I should have checked first. Is that affordable or unaffordable?
It's unaffordable, Judge, and whenever appropriate, if I can make record.
Okay, hold on a moment. Okay. Okay, so you'll have a bond redetermination hearing on Monday before Judge McConicle or Judge Williams, as indicated. And that will be June the 2nd at 9 o'clock. Okay, so Mr. Thomas, you also have the right to a preliminary examination, which is scheduled for June the 18th. And a probable cause conference is scheduled for June the 11th. Probable cause will be by Zoom, and the preliminary exam will be in person. Those matters are before Judge Jacquet. While you're on bond, sir, or as a bond condition, you may not possess or purchase a firearm or any other dangerous weapon, and you may not have any contact with the Joshua Martin. Okay? All right, that concludes this matter.
Judge, if I may.